Rodriguez. Welcome, Senator Dana Dixon. Apologies for absence. We have two apologies, one from Dr. Brown Burke and one from Member Robert Nesta Morgan. All right. We'll go straight into the confirmation of the minutes of the meeting held on Thursday, May 25th, 2023. We'll start with page 1.
Chair, page 1, just formatting under Mr. Jeffrey Foreman's name, where it says Senior Assistant Attorney General Acting. Just for formatting, it can be placed in the right section.
Thank you, Member. We'll move on to page 2. Page 3. Page 4. Page 5. Page 6. Page 7. Page 8. Page 9. Page 10. Finally, page 11. Could I ask for, well, let me see, are there any, confirmation of the minutes, please?
So moved, Chair.
So moved by Member
Seconded.
Gale. Seconded by Member Crawford. Any matters arising from the minutes?
Yes, Chair, I think the issue in relation to revocation versus suspension is something that has been carried over from maybe 2 meetings ago that I think can be dealt with in this meeting. It was referred to in the last meeting as well.
So on page 4 of the minutes, Ms. Gordon-Jones, you had advised, I think it said Mrs. Gordon-Jones stated that the discussion was for the council to instruct the registrar to take the actions in addition to the removal. The clause 64 or 61, sorry.
61 and 64.
Six clauses, subclauses 61 and 64 were to be taken at this meeting. Okay. All right, so please go ahead, technical team, in terms of the matters that we have to deal with this morning.
Good morning. In relation to clause 61, Chair, there was also a slight amendment in relation to 60 subclause 5, where it was indicated that in relation to the entitlement of the full sum to be paid back to the teacher upon being reinstated, and SG had recommended that the wording from the public services regulations be used. So that's subclause 5. You want me to read that one? Where a registered teacher, a licensed teacher, or an instructor has been discharged or acquitted of a disqualifying offense for which the registration, license, or authorization to teach of such person was suspended in the circumstances specified under Section 59, the person whose registration, license, or authorization to teach was suspended shall be A, reinstated as a registered teacher, a licensed teacher, or an instructor, as the case may be. B, considered to be registered, licensed, or authorized to teach on the same conditions that were previously imposed on the registration, license, or authorization to teach, unless otherwise determined by the council. And C, entitled to the full amount of the salary which that person would have received if that person had not been suspended.
Where I would need some clarity is that insertion that speaks to unless otherwise determined by the council. Now, what could that mean? Because what B is suggesting is that the person should be considered to be registered, licensed, or authorized to teach on the same conditions that were previously imposed on the registration, license, or authorization to teach. So you're in fact reinstating the person at their substantive function and role. Now the clarity is unless the council, otherwise determined by the council. What could that circumstances be?
Legal, I think he has a dated document. No?
I would ask.
One you got this morning?
I would ask a question, Minister, on this as well, when you're permitted.
Was the question asked by Member Gale a while ago answered? I'm not sure.
No,
if it was answered,
no,
I'm not hearing.
The term is, I don't think he has the most current version. I don't think you have the most current version. No, but that's not what I have in mind. No, because in the one that I have, C says. So members, there are two different documents. We're trying to ascertain which is the one that we should be working from.
But Chairman, the one that Member Gale read from a while ago, that's what was sent to us in the latest document, sent at about 2:30 something this morning or yesterday morning. Can double check the timestamp on the email. Okay, the one that Member Gale read from a while ago, that was sent to us at 10:36 on the 2nd of June via email.
All right, members, so we're aligned. We're using the document entitled Jamaica Teaching Council Bill, Redraft of Clauses 60 to 85. Right, Mrs. Gordon-Jones? The correct document that we should be using is the one entitled Jamaica Teaching Council Bill, Redraft of Clauses 60 to 85. That's the correct document.
That's it. It starts with clause 60, not 59.
Chairman, can Mr. Nash resend that one to us then? Because that's not the one I have.
Don't worry, I'll just send it to him.
All right. he will recirculate.
You have the right one. I corrected it. That's why I say you have to.
All right, let's carry on, Mr. Gordon-Jones.
Yeah. You have a question.
The clarity that I'm seeking in terms of that insert.
No, I'm just saying that I think the question that Senator Braham has ties into the question that Senator Gale has. So it could be one response as opposed to two.
All right, go ahead, Member Braham.
Thank you. Thank you, Chairman. So before I get there, if you just look at the first page, at 60, 60 subclause 1, and then you see where it said C, the charge is dismissed by a court, and then you see E, the person is acquitted of the offense by a court. I'm not quite sure what is the significant difference. So that is not the question I wanted to raise, but if you could just clarify that for me. What it is that you have in mind to have those two there instead of one or the other. And then that is on page 1. In relation to the question raised by Senator Gill now, my question is, in my mind, if somebody is charged with an offense and they are acquitted, should that be that the person is automatically reinstated, or should the council maintain the residual right to consider the underlying charges? Because of course acquittal may be cases may be dismissed on all sorts of bases, including the fact that witnesses have not turned up for 10 months or whatever the period. So that I am wondering, and I believe that just the mere acquittal should not be the end of the matter, but that at the end of the day there should be a residual right to consider whether in all the circumstances reinstatement, etc., should happen, or should they then have an inquiry because of the particular situation. Those are my two questions, and the second one ties in with somewhat. The question that Senator Gill asks has to do with B. Now, if my question is what was contemplated by the last part of the clause, the phrase there, the sentence that says, unless otherwise determined by the council, if that is what is contemplated, then I would think it shouldn't be where it is, because it then appears to be limited only to the matter that is at B. But I listen.
Go ahead, Dr. Gordon.
Thank you, Minister. Member, please keep in mind that the council has a professional responsibility, and for various reasons, a case might be dismissed. Or the decision taken may very well be within the law, but for example, a girl of 16 is able to give consent, sexual consent, but the teacher is in a school and the girl might be 18, she might be 17. Under the law, the teacher the case may be dismissed. However, ethically, we can't keep that teacher in the school. So there are variations that could require the council to investigate the case further, although under the law, the person is not guilty of the act.
Chair, if we're dealing with what Dr. Gordon would have just explained, and where I would have raised the concerns in relation to 5B. 5B is indicating that the teacher could be considered to be registered, licensed or authorized to teach on the same conditions that were previously imposed on the registration, license, or authorization to teach. So, in other words, in my mind, the teacher who was charged, and in this case now, would get back the license and authorization to teach. Is it that it's being suggested that there may be a situation where the council may now determine that don't go back to that school? You can teach, you can continue to teach, but based on what some employers might indicate that there may be a loss of confidence. So I would prefer you not to come back to this school to teach, but you still have the authorization to teach. Is that what you're suggesting?
No. Once the council investigates the matter and the question of ethical behavior comes up, then you don't teach in any of our schools.
No, so I think it really needs some rewording then, because I do get what Dr. Gordon is saying, which is basically what you asked, whether or not a teacher would be able to be reinstated if, for whatever reason, a charge is dismissed or the person is acquitted. Now, for dismissal, it can be on a technical issue. As you were saying, witnesses don't turn up. If that's the situation, then the substantive matter would not have been dealt with by the court, and the issue would still be live. Now, in a situation like that, do we, because the matter has been dismissed for whatever technical reason, allow the teacher back in the classroom? That is what we need to now figure out, if this is what we're allowing from the wording that we have currently before us.
What the council needs is the power to investigate after the court, for professional investigation after the court. That is what the council needs.
Chairman, if that's the intent, then it's the way it is worded is a little problematic, because you must bear in mind that at 5 says where the registered teacher, a licensed teacher, or an instructor has been discharged or acquitted of a offense. Indeed. But the word discharge is that strikes me. because around the first page it talks about dismissed and acquitted. But I see a new creature here called discharged. I think that you have to try and coordinate them, but there it is. Anyhow, discharged, acquitted of a disqualifying offense for which the registration, license, or authorization to teach of such person was suspended. In the circumstances specified under Section 59, the persons whose registration, license, or authorization to teach was suspended shall be A, reinstated as a registered teacher and a licensed teacher or instructor, as the case may be. So that happens regardless. Once you're acquitted, you are reinstated. And then it says, and it is and, because it's supposed to be and considered to be registered, licensed, authorized to teach on the same condition that were previously imposed on the registration, license, or authorization to teach, unless determined by the council, and entitled to full amount of salary which that person would have received if that person had not been suspended. My own view is that you should have a separate subclause dealing with what the council can do in the case of an acquittal. To hitch it on there is going to be problematic.
With you, because it is as it is now, without that unless otherwise determined by the council, it would flow in a three-pronged effect. In that, in the first instance, you reinstate the person. That's what A was seeking to do. Then B now would reinstate under the previous conditions to which they were employed. And then C suggests that give me back my money that you would have taken away from me and allowed me to suffer during these conditions. But when you put unless otherwise determined by the council, I would have, being a teacher in my mind, would say, so I'm now left to the mercy of the council to determine another fate to which I have no clue. So it ought not to be placed in the same conditions that flows under reinstatement.
Well, it will be useful to know from the lawyers what it is that they intended to achieve, because that would help. I don't know. Very well.
Dr. Gordon gave you an example of the situation that might arise, right?
Chair.
So we need another section dealing specifically with that. Go ahead, Doctor.
The unless otherwise determined, it was based on the understanding, it was in relation to the conditions of the license. So the council may change the conditions of the license of the person. That was why it said unless otherwise determined by the council.
I think that what really ought to happen is that the council should have that residual power as to whether you should be reinstated at all. They would, of course, start a hearing and whatnot if required. So they make a determination, you are acquitted, fine, or your case is dismissed. And they say, very well, you are reinstated, power that they will exercise in their discretion.
I agree with Member Braham.
Fair enough.
I agree with Member Braham.
I hear and I agree, and I'm looking at it, Chair, because this disqualifying offense did not necessarily take place in the classroom. It may have taken place in the public space, which, based on the term, can impose a penalty of imprisonment. Now, I understand what Dr. Gordon would be saying, that notwithstanding the fact that the person may have been acquitted, there still that determination whether or not the school might want back that teacher. Right? And what Member Braham is saying or suggesting, is it that you want the council to conduct its own inquiry on the matter that was already dealt with in court?
No, but he's saying Member Gale, Member Braham is making a distinction between criminal offense and professional offense. So the courts will not deal with professional offense.
No, the court
they will
can't
just
deal with a professional offense.
A criminal offense. So the council wants the ability to deal with professional offenses. That's not dealt with any place else.
I think the council should have that
That's
power,
why
Chairman.
I would not tag it on where
You
it
would
is
make it-
now.
okay.
There has to be a separate area that treats with that specifically in terms of what the intent of the council would be. And not to tag it on where the conditions are applicable to reinstatement and reinstatement under the conditions to which that teacher would have normally operated, and that the teacher is going to be paid what is outstanding. Because the council in this case want an opportunity to make its own determination on the services of the teacher. So it have to be placed somewhere else.
But Member Gale, then you're agreeing with Member Braham. That's pretty much what he's saying.
Member Braham have a way of sidetracking the argument and then coming back to a solution.
All right. So council, we're asking for a clause or paragraph, a clause, a subsection, I don't know what it is, to be inserted to deal with professional offenses.
Madam Chair, if I may, we have to ask ourselves the question whether the council should be given the power or even has the power to deliberate on a matter where a court of competent jurisdiction has already made a determination. Can we then say we can put in the legislation that the council can then deliberate on that matter again?
Would the court have deliberated on a professional conduct matter?
No, then another complaint would have to be brought. It cannot be the same thing because the court has already made a decision on that matter. So I think a separate complaint would have to be made in relation to something else, some professional misconduct or something. And therefore, perhaps it wouldn't be appropriate to put it here.
Sherland, this is specifically speaking to the treatment of a disqualifying offense and not the professional misconduct.
Well, we need a paragraph or clause or section dealing with professional misconduct, not just criminal or disqualifying offenses.
Chair, could we possibly request some assistance from the SG in relation to this matter as to how to deal with this particular situation? Because I don't see why the council should be prohibited from dealing with a professional misconduct issue vis-a-vis the courts dealing with a criminal issue. I don't see what could preclude the council from treating with it. But I'm open to advice from the SG in relation to it.
Good morning, Chair and members and colleagues. So it is allowed under the public service regs, where you have, arising out of the same circumstances, you can have criminal charges as well as disciplinary proceedings. I think right now, though, the public service regs has a provision. I can look back at it where I think it says that the disciplinary process has the criminal process has to be concluded before the disciplinary proceedings can be concluded. And I think that provision is under discussion because I think there is a view that you shouldn't have to await the termination of the criminal proceedings to have the disciplinary proceedings, because technically under law, it's two different standards of proof. The proceedings are different and they would be looking at different, so it might be the same circumstances, but there are different proceedings. So we do have precedent in our scheme here in Jamaica of allowing it.
All right, thank you, SG. All right, counsel. So we'll proceed accordingly.
Yes, Minister, I will insert a clause, but we don't have to take out the words unless otherwise determined by the council, because that is strictly in relation to the conditions where the council can change the conditions under which the person would teach.
All right, we agree. Members? Yes?
I agree.
All right. So there'll be a separate section dealing with professional conduct. All right. Go ahead, Mrs. Gordon-Jones.
Chair, Mrs. Sherland indicated that subclause 4, there was also a change at subclause 4. It was broken out. So I would need to read it for the committee.
It's on the 50, so we could link it to 50.
Is that 60, subclause 4?
60, subclause 4.
Okay, please go ahead.
Where the registration, license, or authorization to teach of a teacher or an instructor, as the case may be, has been suspended upon an inquiry conducted by the Professional Practice and Conduct Committee, the person whose registration, license, or authorization to teach was suspended shall be A, reinstated as a registered teacher, a licensed teacher, or an instructor, as the case may be, and B, considered to be registered, licensed, or authorized to teach on the same conditions that were previously imposed on the registration, license, or authorization to teach, unless otherwise determined by the council.
But isn't there a striking similarity between 4 and 5?
Right, so 4 treats with the suspension after the disciplinary hearing has been held. So before it, the clause made reference to suspension under this act, and it was a wholesome clause. It did not have an A or B, so now it's broken out into A and B. And it specifically indicates that the suspension is after the conduct upon an inquiry.
I'm sorry, you need to help me out a little bit. I'm looking at 4. For where the registration, etc., where the registration, license, or authorization to teach of a teacher or an instructor, as the case may be, has been suspended upon an inquiry conducted by the Professional Practice and Conduct Committee. So, is it to be read suspended because of the inquiry, or it has been suspended and then there is an inquiry? How are you reading that?
So the suspension comes after the inquiry.
I see.
Maybe you don't need a comma. Maybe you don't need a comma between suspended and upon. Maybe.
So they suspend you after an inquiry, and I think that probably for certainty we may either flip it around or something there, but if that is the case, but you are suspended after an inquiry, and then we are saying the person whose registration was suspended shall be reinstated. You are suspended, and then we are saying, I don't know, help me, shall be reinstated. On what basis?
So, for example, the inquiry was held, the person is found guilty. The penalty that is going to be handed down is the suspension. So the person might be suspended for, like, just say 4 weeks. Upon the ending of that 4 weeks, those 4 weeks, then the person would be reinstated.
Okay, it's not.
That's not what it kind of said, though.
No.
Yeah, I'm not getting that from what's written there.
I was just informed by my colleague that at the end of a suspension, those words are to be kept. So,
can you reread it again, please?
Where the registration, license, or authorization to teach of a teacher or an instructor, as the case may be, has been suspended upon inquiry conducted by the Professional Practice and the Conduct Committee, at the end of that suspension, the person shall be reinstated as a registered teacher, a licensed teacher, or an instructor, as the case may be, and be considered to be registered, licensed, or authorized to teach on the same conditions that were previously imposed on the registration, license, or authorization to teach, unless otherwise determined by the council.
Okay, Ms. Wilkins, please go ahead.
Could we just get back that section?
Thank you, Chair.
Out of it?
Thank you, Chair. Morning.
Okay, one
to
second,
everyone.
Ms. Wilkins. Sorry, Ms. Wilkins, before you go.
Oh, sorry.
Before you go.
Sorry.
All right, go ahead. Sorry, Ms.
Go
Wilkins.
ahead. Yeah, I just wanted to point out that that doesn't fix the problem. I think the problem is the outcome of the inquiry is what is to determine if a person is to be reinstated, not at the end of. What if the inquiry resulted in the person being deemed culpable in some way, or their conduct wasn't appropriate for some reason? You will want to just reinstate them because the suspension period has ended, or the inquiry has ended, so put them back in. I think that's where the gap is. So even though the proposed fix, it only partially did to the, we don't know the crux of the matter that Senator Bram is raising in my view. Thank you.
It's the open.
All right, the technical persons are conferring. All right, what's the result of the discussion?
Chair, I think is really a an interpretation issue or the wording. So what Mrs. Gordon-Jones is explaining is that the suspension would have happened at the end of an inquiry, meaning this would have been the disciplinary action taken, a suspension. And then at the end of that suspension, the person is reinstated. But based on how it is worded, it can be misinterpreted for us to think that the suspension is pending an inquiry, which at the end of the inquiry, you could have other actions coming from it. But that is not what is intended. What is intended is that the disciplinary action is already the suspension. And then at the end of that, the person is reinstated. Yeah.
Honestly, I never read it like that. How I read it was that this was an administrative type of suspension to allow the inquiry and all that to take place, but you wanted to remove the teacher from the classroom. So what you're saying to us now is that this is actually the imposed sanction as a result of the outcome of the inquiry.
Yes, you have that correct, Senator.
Okay, Ms. Wilkins, is that consistent with what you were just saying?
No, Chair. I think there more is needed. It should indicate that where the suspension flows from a decision of the committee having conducted an inquiry, and that the suspension is the totality of the outcome that this committee has put forward. The gap is still there.
Yes, Chair. So it would require the rewording.
To have a protracted discussion to try to interpret a provision. If we are doing that, it means it's not clear enough, and it needs to be redrafted. In my opinion.
Agreed, Chair. So we're saying that it has to be reworded for it to state exactly what was just said.
The sequence of events, essentially, right? Yes. All right. Meaning that there would have been an inquiry first, and that inquiry would have resulted in a suspension. And this would then be saying, after that suspension has ended, the teacher would be reinstated.
But the question that we have to ask, though, why do we need, if that's what it means, why really do we need a clause to say that when your suspension is finished, you are reinstated? Wouldn't that be automatic? Is it? No?
If I may, and I think I'm in agreement with Senator Braham, because if it is that they're not going to be suspended during, what this is saying is they're not going to be suspended during the inquiry. Is that correct?
No, member. The legal team is conferring.
Chair, can I reread the clause for the committee for them to determine whether it is clear?
I'm sorry, which clause?
Subclause 4, 64.
Just repeat what you said, please.
I'm going to read the redrafted clause for you to determine if it's clear enough. Where the registration, license, or authorization to teach of a teacher or an instructor, as the case may be, has been suspended after an inquiry conducted by the Professional Practice and the Conduct Committee. At the end of the suspension, the person shall be reinstated as a registered teacher, a licensed teacher, or an instructor, as the case may be, and B, considered to be registered, licensed, or authorized to teach on the same conditions that were previously imposed on the registration, license, or authorization to teach, unless otherwise determined by the council.
Sounds clearer.
It sounds clearer. Yeah.
So that contemplates that a disciplinary action would have been taken as a result of the inquiry, which would have been a suspension. And then once the period of suspension would have been concluded, then the person is reinstated under the similar terms and conditions of employment. That's clear. Unless otherwise determined by the council.
Okay. Ms.
Whichever
Wilkins,
case
is
may
that
be.
consistent with what you were saying? Ms. Wilkins?
Good morning, Cherie Spence here, Legal Officer for the Legal Reform Department. Ms. Wilkins stepped out for a moment.
Maybe we could move to something else until she returns, Chair.
I'm sorry, member. SG, you have your hand up. Please go ahead.
Yes, actually, I was looking to put the hand up. Thank you. Thank you for recognizing me, Chair. I actually have, my comment is not on this point. It's on the previous intervention I made. I'm not sure if you want to take that now.
Please go ahead, because I think it's in keeping
Okay,
with the discussion.
Thank you. So I need to correct myself, and I apologize. So earlier, I made an error. So I've looked back at both the public service regulations and the police service regulations. And in both, where you could have started disciplinary proceedings, but if criminal proceedings are instituted that arise out of the same facts, the disciplinary proceedings have to be halted, and then the criminal proceedings have to be concluded. If the person is acquitted, then both regulations say that the officer shall not be dismissed or otherwise punished in respect of any charge which he has been acquitted. So once there's an acquittal, the person cannot be dismissed.
So that is what, Chairman, those regulations provide for. And that
right. I'm not saying it cannot be done generally. I'm just saying that I had indicated there was precedent, but I was wrong.
Yes, but those regulations provide for that situation, and I'm sure consideration should be given or is being given as to whether policy-wise that is the best formulation.
No, and that is correct, that the provision, well, certainly on the provisions, because it's two different regulations, the provisions in the public service regulations are under review, and it's my understanding that there is consideration being given to have the proceedings being conducted simultaneously, meaning you could have the disciplinary proceedings and the criminal proceedings being done at the same time. Now, what that suggests to me, though, is generally the way how disciplinary proceedings can be conducted, those could be concluded before the end of the criminal proceedings. So you could, if there are changes made, it is possible that you could have someone dismissed before the criminal proceedings are concluded.
Or the tribunal that is doing the proceedings may in its discretion adjourn it until after the trial. But
yeah, correct. That's correct.
And so after the trial, they could then resume the hearing if they so choose. I just want the authority or the tribunal to have the power to make and to exercise a discretion.
Right, I understand.
Remember, Graham, that discretion is in relation to a possible different outcome?
Yes, I mean, if when I say possible, you mean if they should choose
yes.
to engage in a hearing, the outcome may be that they find a disciplinary offense has been committed, and they may take actions accordingly. Or they may find that none has been committed, or they may decide that they will stand by the decision of the court. It was not necessary to do anything further except to reinstate, etc., etc.
You know, my preference has always been, if there's a matter before the courts, allow that process to take place before any other inquiry is held. Because you run the risk of, at the local level, making a determination on the outcome, which may be different than the outcome in relation to the courts. And if the courts would have dismissed the charges in this case of a disqualifying offense, then are you going to conduct an inquiry and dismiss the individual? That, in my mind, would be contrary to the outcome of the court.
But member, I thought we were making a distinction between disqualifying offenses or criminal offenses versus professional offenses that the court is not going to necessarily adjudicate on.
No, I'm very clear on the fact that the court is not going to adjudicate on disciplinary offenses, you know. But I was going based on what the Solicitor General is saying about the review on those two other applications in terms of the public sector and the police. I'm just cautioning against an application that would preside over the two running simultaneous.
Go ahead, Dr. Gordon.
Sorry.
I can understand not having both issues running simultaneously. There can be a halt of the discussion at the level of the council while the court proceedings are going on. However, the council must have the professional responsibility to decide whether that person is suitable according to fit and proper for schools. The person might be fit and proper for the society and is not fit and proper for our schools, to teach in our schools, to be among our children, to be among our girls. That has happened and it can happen again.
The Chairman, I do understand the discomfort of having simultaneous hearings, and that may not be the first option. The committee may choose to adjourn the matter pending the hearing. But then, you know, there are court matters sometimes that take years. Years, believe me. And it is adjourned for 5 years, meaning the disciplinary hearing, or even 10 years. And then after that, there is an acquittal because, of course, the witnesses have all migrated to New York. So, in those circumstances, the disciplinary process would be permanently crippled. And at the end, the person would then be acquitted. And then, of course, after 5 years, the disciplinary process is also crippled because you don't have anybody to be witnesses and so forth. So you have to take that into consideration in regard to the system that we are presently operating.
I agree. I agree,
yes,
member.
yes,
I agree, member
I
Braham,
accept it.
because we have seen how crippled we are currently, and I think that's what we're trying to reform in this act. All right, so Ms. Charlon, there will be, can you go again? There will be a separate section. Go ahead, Ms. Charlon.
I'm just saying, yes, Minister, that I will draft another provision. In fact, I was trying to draft something, but of course I'll wait until the next occasion when I've thought about it properly.
All right, so please continue, Ms. Gordon-Jones.
Just to clarify, Chair, in relation to the redraft that was read, if the committee is accepting what was read for subclause 4.
Chair, can we ask for it to be reread, please?
Sure, go ahead, please reread.
Where the registration, license, or authorization to teach of a teacher or an instructor, as the case may be, has been suspended after an inquiry conducted by the Professional Practice and the Conduct Committee. At the end of the suspension, the person shall be A, reinstated as a registered teacher, a licensed teacher, or an instructor, as the case may be, and B, considered to be registered, licensed, or authorized to teach on the same conditions that were previously imposed on the registration, license, or authorization to teach, unless otherwise determined by the Council.
Are we in agreement, members? Yes. But there'll be a new section. All right, there'll be a new section to deal with professional conduct, for the council to be able to deal with professional conduct. Okay. Please carry on.
61.1. The revocation of the registration, license, or authorization to teach of a teacher or an instructor, as the case may be, by the Council in relation to a disqualifying offense remains in effect during an appeal to the tribunal. 2. Where the Professional Practice and the Conduct Committee decides to revoke the registration, a license, or an authorization to teach of a teacher or an instructor, as the case may be, under Section 58 or 59, the Council shall, on receipt of the decision, A, instruct the registrar to remove the name of that person from the relevant register or roll, and B, publish the decision of the Professional Practice and Conduct Committee in the Gazette as a daily news and a daily newspaper circulated in Jamaica. 3. Where the revocation of the registration, a license, or an authorization to teach of a person relates to the conviction for a disqualifying offense, the person whose registration, license, or authorization to teach has been revoked may apply for reinstatement, A, after the penalty for such disqualifying offense has been paid, and B, having furnished the Council with any prescribed documents and information required by the Council. 4. A person...
Just one moment, please. Just one moment. I just want to... Could you just read 3 again, please?
where the revocation of the registration, a license, or an authorization to teach of a person relates to the conviction for a disqualifying offense, the person whose registration, license, or authorization to teach has been revoked may apply for reinstatement, A, after the penalty for such disqualifying offense has been paid, and B, having furnished the council with any prescribed documents and information required by the council.
Well, so let me ask you, the reference to the payment of the penalty, after the penalty for such disqualifying offense has been paid, could you tell me what's the thinking?
Yeah.
Suppose the person went to prison. Well, you can pay too. It can be either.
No, well, the disqualifying offense is a 2-year
Yes.
imprisonment. That's what it says. This interpretation is
Yes.
2-year imprisonment. So it can be a pay. It can be a. I want further clarity as well in relation to this application for reinstatement after revocation. So, after somebody has served their time for a disqualifying offense, and they furnish the council with documents, are you saying that that person may be reinstated after revocation? Why? Somebody has been convicted of rape, for example, and has served their 7-year sentence. Are you saying that that person, after they have served their sentence and furnished documents, can now apply to be reinstated?
If I may, I mean, I am having a difficulty with this. That the person would even have any reason to apply or to reapply after conviction, and especially in something like a rape charge, and they were convicted, to be able to possibly be reinstated back in a school. I think I'm having a difficulty, and I'm not sure why this clause is there.
The issue, though, I don't have an issue with the council having a power to consider an application for reinstatement. But I get a sense of the way it is written, almost as if, well, I'm out of prison today, and I send in my papers, and I am...
Yeah, it's automatic. So we must put some other conditions here.
You can always apply, but you know, well, you see, because there may be lesser offenses, not as egregious as the one mentioned.
Yeah, but it can't be a disqualifying offense.
It
must be another offense. So the reinstatement, the consideration for reinstatement can be based on a disqualifying offense. For me, it must be something lower than that.
Madam Chair, may I?
Please go ahead, Senator.
I'm having serious issues with that clause, because if it's a disqualifying offense, I absolutely agree. We cannot be reinstating someone who has been convicted of a disqualifying offense in this seemingly very easy manner. Oh, okay, I've paid my time and I've paid whatever I've been asked to pay. That's not possible. I mean, I don't think that's the spirit of what we're trying to achieve here. If it's a disqualifying offense, it is a disqualifying offense that has been committed by someone, and I think that should preclude them from being deemed appropriate to be in a classroom.
See, Chair, there can be a disqualifying offense has no limitations. can be broad-based. What this is assuming is that notwithstanding the disqualifying offense or the time served, yes, it's may. And may is an automatic that goes both ways, that you may or you may not apply. But you are given the opportunity here to make the application. Now, but it gives my concern is that it gives this impression of the opportunity for an automatic application that may very well raise the expectation that I'm going to be granted. And so this is a situation that would require possibly the council that they have to consider the application, but this is not being said.
My fear also is that you may have somebody on the council who, after somebody has decided to apply after disqualifying offense has been served, may consider that application and may want to reinstate that person. So it is a discretionary thing to me. I think, right, I may encourage it, and I think we need to just dismiss that. It doesn't matter if it's a one-man thing. You may have somebody on the council who may be very persuasive. No, I don't want anybody to think that after they've served a prison term of 2 years or more, think that they can even apply to be reinstated. You should just dismiss that altogether. Just forget that part of it.
I think I'm in total agreement with Member Toval, Hamilton. I'm having a real difficulty with this particular clause here.
Chair,
go ahead,
in addition
Ms.
to
Wilkins,
agreeing with...
I'm sorry, hold on, Member Crawford. Ms. Wilkins had her hand up. Go ahead, Ms. Wilkins.
Yes. Thank you, Chair. I think it would be helpful if there was a better understanding as to what kinds of offenses are disqualifying offenses. I believe there was a discussion previously that the definition in the bill, well, that first drafted, was extremely loose, extremely wide. And even though we're discussing it, I don't think there are too many of us who have an appreciation of the categories of offenses for which a sentence of 2 years or more is imposed. And we may well find that having some information provided on that, which LRD could assist at the next meeting by providing that kind of information, I think we're in a better position to discuss how to treat with a person who committed a disqualifying offense. Or maybe at the end of the day, we may tweak that definition of disqualifying offense to make it more pointed so that we are keeping out the persons who need to be kept out. But as it is now, it is very wide. And I submit that we can undertake to provide at your next meeting, or we could do it prior to the meeting and circulate it so everybody could look at it prior to the meeting, some notion as to the categories of offenses that would be captured by this loose definition of a sentence of 2 years or more. Thank you, Chair.
Member Crawford. Member Crawford.
Thank you, Chair.
Yeah.
Thank you, Chair. What I wanted to add that in addition to agreeing with Member Hamilton and the example that she gave, I wanted to suggest that the bill not only include offenses committed on the Jamaican soil, because I know of an example right now of a teacher who was imprisoned in another Caribbean island, a Jamaican teacher, for some sexual misconduct. He would have served this time and he has now returned to the island. So I want for the provision to include not just offenses committed on the Jamaican soil, but if they're committed outside of the Jamaican soil, I'd want us to consider that. And I do agree with Ms. Wilkins that we perhaps should establish those offenses that we want to take the drastic actions against, rather than having it so wide. This example of the sexual misconduct or rape, that's one of the extreme. Maybe we should add some others.
But I think what we're saying by disqualify, the way we've described disqualifying offense right now, is anything that you go to.
How we have it now, Chair, is penalty of a term of imprisonment 2 years or more.
Yeah. So what is wrong with that?
Well, based on what Ms. Wilkins is saying,
she's saying she thinks it's too wide.
We need to identify specific
offenses
for which.
Why?
I'm not sure.
Why? You've gone to prison. You've gone. That's not what we should be teaching our children.
If I may, Chair, through you, Chair, 2 years or more, I think, would be for a particular type of crime, correct? Therefore, I don't think it would be necessary to spell out what those are, because it might be just too broad or too many things to spell that out. So if it is that it's 2 years or more, that would be for something specific, according to the law, what those crimes may be. So if it is that we're going to go that way, I don't think it should. That's just my opinion. I don't think it should be spelled out because.
Chair, I don't think that's what Ms. Wilkins was trying to say. I think she was trying to say, in order to aid in the discussion, for members to have an idea of what some of those charges, those disqualifying offense, may be by virtue of the definition. So you can assist in the discussion, not for it to be indicated in the bill, but to aid in the discussion.
That's what I understood Ms. Wilkins to have said.
Or Member Green, please go ahead. But remember, guys, we're not trying to go backwards. We're trying to go forward. We've already agreed that if you go to jail for 2 years, that's a disqualifying offense.
Chair,
so 2 years or more, that's a disqualifying offense. But Minister Green, yes, go ahead, Minister Green.
Chair, so I think the point raised by LRD is a good point that we have to consider, and we have to look at how are we considering it. So there are a wide array of offenses that may fall in the imprisonment for 2 years or more category, right? And, we probably should look at the full total of those offenses, because clearly, we appreciate the examples of very vicious crimes and crimes that have to deal with a sexual nature. But there are also a wide array of other sorts of offenses that may carry this penalty. So the question is, should the law allow the council to be able to consider somebody who has committed an offense for reinstatement? And the principles are sometimes very difficult. Again, if you use offenses of a sexual nature, you would say automatically no. So maybe if we want, we could specifically take out some offenses that you would have no right of consideration, right? But then there may be other offenses. Remember, and I'm not saying that this carries a penalty like that, but there was a time in Jamaica where consuming certain products was considered a criminal offense. Would we say automatically that if somebody is convicted of that they should not be in the classroom? And again, we always have to contemplate the other side of the coin. May have an excellent teacher who the offense is not related to anything that's injurious to a child, may have been involved in let's say a fracas, right, under circumstances where somebody was injured and they have been convicted, but the record prior to that was exemplary and the person has proven to be an asset to the school system. Should the council be able to consider an application for reinstatement, for example, under those circumstances? So the reality is that it's very hard to legislate for every single circumstance that would come up, right? But I believe that the council should have a right to consider, because I do believe that we have a wide assortment of charges that carry imprisonment 2 years and above. However, I do believe that we may want to specifically exclude certain offenses from this provision. And I think if we were to say that if the person has paid the penalty, then they may apply for reinstatement, save and except if the offense was in this category, then we might be able to satisfy the person who, or the situation where the offense is not of a nature that we think is injurious to children, while also keeping out predators, etc., out of our classroom. So I think we have to strike that balance. And I'll just make one final point. You know, it's not in every occasion that somebody who would have committed an offense and serve a penalty, that, you know, we have to be careful how we completely ostracize those persons from society, especially if the penalty isn't one of a nature that we find specifically, you know, injurious to our children. Thank you, Chair.
Thank you, Member Green. Member Hamilton?
Yes, Chair, I think that was a mouthful. But I do agree with the member, but I think what we can do is maybe revisit our definition of what a disqualifying offense is.
Well, we already defined it as anything that
well,
you, yeah.
Yes, but it would help somewhat for us to review the definition. But I also see at clause 4 where there is opportunity being granted to persons who would have had their license revoked to apply for reinstatement in circumstances where it is other than the conviction of a disqualifying offense. So we're not precluding persons who may have experienced or gone through a revocation from reapplying. We're just saying in what circumstance. So in a situation, based on what Member Green just said, it would probably help the discussion a little bit more for us to determine what it is a disqualifying offense is. Why? Senator Braham and I were having a sort of voce conversation in relation to, for example, manslaughter, where somebody was convicted and given 1 year imprisonment. The person could have been given 2. That person would have been precluded from going into the classroom if he was given a 2-year sentence. So maybe we need to probably reconsider that, Chair. I think it would serve us best for us to put some context to the 2-year. My 2 cents.
All right, members. I remember, go ahead, Dr. Gordon. You want to go ahead, Dr. Gordon?
The issue is empowering the council to reinstate a person who has been, who was guilty of a crime and served his time somewhere or paid for the crime, whatever. Now, the council is the body that is responsible for professional conduct. So, remember the size of the council that will take a decision on whether such a person, having served the sentence, can now be allowed in the presence of children. And that decision is a decision that the council makes for all teachers. It is the council that determines that the person is fit and proper to teach. And I can't understand the reason why in some cases the council would not have that power. That is not clear to me.
Because, Dr. Gordon, I don't believe that for certain offenses, people should even think of reapplying. I really don't think under certain circumstances that even should be allowed. Now, I do accept at clause 4, where it says a person whose registration, license, or authorization to teach has been revoked for a reason other than the conviction of a disqualifying offense may apply for reinstatement. I can accept that, but I will never be able to accept someone being able to reapply after a disqualifying offense has been served. I can't see it, which is why I'm saying maybe we need to define further what it is we're considering disqualifying offenses, because to my mind, you can't come back from that and be placed back in a classroom.
Chair.
Chair, I think that the law should be very clear on which disqualifying offenses, under disqualifying offenses, that a teacher should not be readmitted in the classroom.
But members, remember we have a definition for disqualifying offense.
But that's, well, Member Hamilton did indicate that perhaps
if you go to jail for 2 years or more, that's
Chair.
a disqualifying offense.
Chair.
Yes, Ms. Wilkins,
Chair,
go ahead, please.
Based on, it's Mrs. Gordon-Jones.
Oh, should I? Chair, I was just saying that the example given by Member Hamilton a while ago was a perfect example, because a vehicular offense can result in a person being incarcerated for 2 years or more. But that
what is that offense, Ms. Wilkins? Ms. Wilkins, can you say what
Chair.
that vehicular offense would be? To be exactly. So why? Go ahead.
Well,
Yeah,
I'm
go ahead,
sorry,
Ms.
Chair.
Wilkins. I'm asking you. You just said a person can be convicted of a vehicular offense and go to jail for 2 years or more, and I'm asking you to give us an example of what that vehicular offense could be.
It would quite likely be one where there was a fatality, and whether by an error on the part of the driver of the vehicle, whatever, it resulted in this fatality, and the court had a finding that the person should be punished for it. And I'm saying that is a good example of a case in which the council can look to see whether this is a wholesome individual who made an error, who paid the price for that error, but nevertheless is someone who can continue to serve in the profession for which he was trained, he or she had been trained. I just think that providing more detail to the definition or vesting some discretion in the council would ensure that we don't lock somebody like that out of the profession. Thanks, Chair.
Go ahead, Ms. Gordon-Jones. Thank you, Ms. Wilkins.
Thank you, Chair. The proposed clause, based on the discussion in order to exclude some of the offenses that would have been committed, the proposed clause is notwithstanding subsection 3, a person who was convicted of an offense under the Child Care and Protection Act or the Sexual Offences Act may not apply to the council for reinstatement as a teacher or instructor.
That's too narrow.
Where would you put that?
That's way too narrow.
Under 61, after the clauses that we just read, it would be subclause 5. And then
Remember, Chair, what we're considering is the right to apply now. It doesn't mean that they will make it back into the classroom, because the council will have to consider it. The question is, who should or who should not have a right after committing a disqualifying offense, should have a right to apply? Should anybody have the right to apply once they have committed disqualifying offense? Should a select group have the right to apply, or should everybody have the right to apply?
But
I agree with Member Hamilton that there should not be a broad, everybody shouldn't have the right to apply. But I would say that what we should do is specifically, as I've said, specifically exclude those who we think should not have the right to apply. So again, I would suggest that we get the list of the offenses that carry the penalty so that we know what we're looking at. addition is good, but I understand you're saying, Minister, it may be too narrow. But those are definitely two of the areas that I think we can automatically pick out and say we should those people. But there may be others, so maybe when we have the list and look at it, we could pick some more areas that we would want to exclude persons.
Minister, assuming that we are going to revisit the definition, because I am fearful if you list definitions, if you list offenses, you're going to exclude some, because of course we have heard about the sexual offenses and the child care and protection, but you have offenses against the person, a touch of murder and a touch of assault and that sort of thing. Plus you have thieving, which are offenses as well. So if you're going to redefine it, maybe if you could put something to the effect, an offense involving moral turpitude, I don't know. One way of doing it is to deal with it with a sentence, 2 years, at least 2 years, and that is easy. That is easy. I do have a slight discomfort. I have a sort of general view that maybe we could allow people to apply after at least 5 years or something, but I am open to persuasion, Minister.
Go ahead, Dr. Gordon.
Considering the composition of the council and their stakeholders' representation, could one consider indicating that the decision has to be based on a consensus of the council? The decision to reinstate a person whose license has been revoked. There must be the consensus of the council.
Okay, Dr. Gordon, I don't believe that is where we were. We were, at least when I listened to Member Hamilton, she was saying, should that person even consider applying? I mean, if it's a disqualifying offense.
But the right to apply is a person's right. It's whether or not we consider the application. Because the person has a right to apply. And under the Constitution, nobody is condemned for life. Once you have served your time, then one has the opportunity through several processes to be reinstated in society. So what you're actually doing is giving the council a power. The council is empowered. And for that person to be reinstated, there was going to be a long process or an integrated, a strategic process, whatever the term we want to use. But do we want to say that once the license has been revoked of any such person, that person cannot be reinstated as a teacher? I don't know if that's what we want to say.
Why are we calling it disqualifying offense then? It means you're disqualified from teaching.
Yes, Minister. And I know what the disqualifying offenses are. However, there can be persons who were found guilty of disqualifying offenses, but the very nature of the offense is such that if the person goes through a process of retraining, counseling, and other areas based on character support and so on, that the person may be considered.
Do they have to go back in the classroom? Are there other professions to which they can go? Is it a right that they go back into the classroom?
No, Minister, we're not saying it
We've
as a right.
We've said it's a disqualifying offense.
Minister, I have a suggestion.
We're not seeing it as a right, but rather
Minister,
an opportunity is there. Should that person be considered by the council and all the stakeholders of the council somebody who is now fit and proper to return to the classroom?
Go ahead, Member Green.
Well, I'll make one point and then I'll make a suggestion. I think, you know, we also at some point, and, you know, we're establishing a council, and, you know, we have tried to put it together in such a way that we have multiple stakeholders. So what this does, again, is give the right to apply, but it would be the council who makes the determination. And, you know, I think in a number of the instances, I don't know if our fear that the council may make the wrong decision should guide us. But I have a suggestion. Why not tie the right to apply to expungement? So where someone has had their record expunged, then they can apply for reinstatement.
Chair, the difficulty I'm having though, so I can understand when somebody has been convicted, done their time, and needs to be reintegrated into society. But that's a different bar that we are now setting for being within classrooms and with our students, with our children. There's no issue, I have no issue with somebody reintegrating into society. But for me, there is a higher standard that I will set where somebody now is being exposed to our children. I really, there is no argument, Chair, that can convince me that somebody who has been convicted of a disqualifying offense should be able to make a mark on impressionable minds. It is just too difficult for me, which is why I'm saying maybe there are particular circumstances that Dr. Gordon is referring to where somebody can come back, but those will have to be stated for me to be able to appreciate what is being said.
Okay, yes, Ms. Wilkins, I see your hand, but members, I bring you back to a disqualifying offense. We've already given a definition to it as an offense for which the courts of our land has said you go to jail for 2 years or more. So I don't know why we're coming trying to rework that and be soft on that when we're talking about our children. And I agree with you, Member Hamilton, it's a much higher standard, a much higher bar. Mrs. Wilkins.
Thank you, Chair. I think the issue that we're having is for the legislation to essentially be saying the fact that an individual was incarcerated for 2 years or more, regardless of the reason, that person is barred from this profession. That is essentially what we have here. And that is where the difficulty lies. It doesn't matter what the offense is, they were incarcerated for 2 years or more. And that's all. I think that is really the disquiet that we're having. Thank you, Chair.
It seems in my mind that where we are left is now the discretion of the council to make a determination. Because Member Hamilton raised, and Ms. Wilkins raised the point around someone who may have been involved in a motor vehicle accident that has caused manslaughter. And you can get up to the 2 years. Is that a person that should be defined as committing an offense, disqualifying as it may be, not to have in the classroom? No. And the rubric of the disqualifying offense is for 2 years or more. So again, it's going to be left up to a council making a determination on the submission. What I'd want to ask, B speaks to any prescribed documents. that ought to be submitted in the application? Are we going to determine what that list of prescribed documents ought to be? Because once we use the term what is being prescribed, it ought to be established and determined. So I think in my mind, I'm over the hill since we can't list out the disqualifying offense. As Member Braham would have said, somebody is going to say you exclude one or two. So it's left up in my mind to the council to make a determination. So I'm gone now to talk to me about the prescribed documents, the evidence that ought to be submitted for the council to make the determination. Member Green raised the concern about the possibility of expunge, but then would have to determine that time frame that is going to cause for qualification of expungement.
But there's a time frame on the law for all offences.
Remind me.
Not all, but more. It depends. It depends on the length of time served. Not all offences can be expunged, but the vast majority can be, and it depends on the time that you would have served, and there is an add-on time on that for rehabilitation. I don't remember, maybe LRD can give us the broad categories, but it depends on the time. But in my vague recollection is, for example, if you would have served 2 years at minimum, there's another 2 years, plus could be another 2 years. I don't remember, but in my mind, there's some double the time in terms of the time needed for rehabilitation. But LRD could guide us. But again, I'm back with your point, Member Gale, that I believe that there may be occasions, especially based on the time frame that we have set, there may be offences that you would still have people who you would want in the classroom, regardless of the fact that they committed an offence. And again, I think a good example has been used in relation to maybe a motor vehicle crash. But again, if we get the offences, maybe we'll be better guided.
Senator Dixon.
Thank you, Madam Chair. I'm still a bit concerned about someone with a disqualifying offense being able to be reinstated basically right after they've served their time. And I think the nomenclature is very important. Disqualifying offense, and disqualifying has to have some amount of weight to it. It's an offense that makes you ineligible to be in a classroom. Now, I agree that there can be some level of rehabilitation tests that can be built into the review that would be done by the council. But I do believe, I mean, if we could go where Minister Green is going, that any application would have to be after that expunction is done. You know, if that's what it is, fine, because that would then lead us to have some element of rehabilitation in there. But the notion that as soon as you have served your time for a disqualifying offense, disqualifying is very important. That term is important. It means you're disqualified to be in the classroom. I think maybe we can open it up a little bit to have a way of testing that this person has been rehabilitated, but I don't think it can be anything that is immediately after that sentence has run its course.
All right, thank you, Member. SG, please go ahead.
Thank you, Chair. I just wanted to perhaps just make a comment or two on the proposal from Minister Green regarding referencing the offences that have been expunged. Whereas I can understand the concept and the proposal, I would urge caution, because the Criminal Records Rehabilitation of Offenders Act has a certain type of scheme. So once your record has been expunged, you actually have no record. So it's not like you would have something to say, I had a conviction, I no longer have it. You don't have a record anymore. That's the effect of the expungement. Perhaps though, what could be done is, if you're going in that direction, you could look at the lists the third schedule, which lists offenses which may not be expunged. Perhaps if you want to change your regime now, you could look at identifying those same offenses and saying that 3A would apply if you have been convicted of one of these offenses. So that is one way of doing it. And I just want to remind the committee, the term disqualifying offense is not just used in this provision. So, and that's the reason I'm making a new suggestion that perhaps you don't want to use the term here. Remember that the term is used in relation to fit and proper criteria. And so perhaps what you want is your own discrete. It could be that you have a discrete list in a schedule to address the issue that Member Briam has raised about what if you have left off an offense. You can have a mechanism to allow for an easier mechanism to amend that schedule. But you perhaps would be going along the right track if you used the offenses which cannot be expunged. Thank you,
Okay,
Chair.
so SG, sorry, in all of that, are you saying you're recommending against not using after expungement?
Right. I would prefer that we not try to because it means the person would have to provide proof that they were convicted and then their offense was expunged. And that is not quite consistent with the scheme in the Criminal Records Rehabilitation of Offenders Act. But I'm saying there's another way to get to the same objective, which is that you could list the same offenses in the third schedule of that act. You could list them here. And you could say that it would apply to persons who were convicted, and you list these offenses. So it would achieve the same thing.
As usual, Chair, I agree with SG.
What, to list the offenses in the, what did you say,
That
third
we could
schedule?
achieve the same thing by excluding offenses that cannot be expunged.
All right, members. So, Member Hamilton, if you could just read through those and state what is the middle ground here.
Chair, based on what the SG just recommended, I took a look at the Criminal Records Rehabilitation Offenders Act. The third schedule referenced offenses for which convictions may not be expunged, and they include murder, any offense under Section 2, 3, or 4 of the Treason Felony Act, any offense under Section 3 or 10 of the Malicious Injuries to Property Act, any offense under Section 37, 39, 40, 42A of the Larceny Act, offense under the Firearms Act other than an offense under Section 11, 12, or 14, offense under Section 8, 13, 14, 15, 16, 17, 20, 33, 69, 70 of the Offenses Against the Person Act, any offense under Section 3, 5, 6, 7, 7A, 8, 8A, 9, 11, 21A of the Dangerous Drugs Act, any offense under Section 4 of the Trafficking in Persons Prevention, Suppression, and Punishment Act, any offense under Section 10 of the Child Care and Protection Act, any offense under Section 3, 4, 5, 7, 9, 10, subject to Section 20A of this Act, 11, 13, 15, 16, 17, 18, 19, 20, 21 of the Sexual Offenses Act, treason, any offense under Section 3, 4, 5, 6, 7, 8, 9, 10, 11, 12 of the Law Reform Fraudulent Transactions Special Provisions Act, any offense under Section 3, 4, 5, 6, 7, 8, 9, 10, 11, or 12 under the Terrorism Prevention Act, any offense under Section 3, 4, 5, 7 of the Child Pornography Prevention Act, and any offense under the Criminal Justice Suppression of Criminal Organizations Act.
All right, so essentially we would be saying that persons found guilty of those offenses, Member Hamilton, may not apply, or if they apply, the council can just strike them off.
Well, that would be the thinking, Chair.
Yeah. All right. And for all the others.
But Chair, I think we should also just do some due diligence to determine what exactly these provisions relate to, because they've excluded some. So from my own mind, I would love to be able to just go through them to make a determination whether or not we're okay with just this. We're okay with what is here.
In that regard, if I may, Chair, you'll recall that we now have a new Firearms Act.
Exactly.
So in fact, this reference, right, so I would suggest, because there needs to be some rationalization with this and the new Firearms Prohibition and Regulation Act, I think that's the name of it, because this would be different. So that is one act where there would need to be some review by the ministry in terms of the proposals as to the exclusion, the offenses that would be now excluded for this bill.
Okay, so I'm asking our legal team to take the discussion into consideration in terms of the amendments. Yes, Dr. Gordon? So if I understand it, we're saying for persons that are convicted, right, under the third schedule, is that what you call it? What's the name of it?
It is the Criminal Records Rehabilitation of Offenders Act. Third schedule.
Those offenses listed there that are not expungible, those persons cannot apply. But others can apply, and it will be the consideration of the council. Dr. Gordon?
Chair, can we defer this to the next meeting? Because as SG is saying, we need to review to ensure that these are current. So the thinking is
the principle.
Very well.
Principle. Ms. Gordon-Jones, you wanted to add something?
Chair, we will look into the act that Member Hamilton indicated and see which of those would apply in the circumstances.
What do you mean, which of those would apply?
Based on my understanding, even though they are not, even though they cannot be expunged, it does not necessarily mean that the person cannot work. So we would have to look to see if it applies, if we want it to apply to a teacher not being able to re-enter the classroom. That's what you were saying, Ms. Member Hamilton?
No, why? Go ahead, Member Hamilton.
No, I'm just wondering if we're having what's the difficulty? The application of this to the reinstatement?
Right.
So we're saying that these offenses that have been listed could be used to apply in relation to the reinstatement section to say those persons who've been convicted of these offenses cannot re-enter the classroom. I think that's the line of thinking that we're going on.
Right, but I think Minister think that it should be all of them.
Yes, all of these offenses.
Yeah.
Yes.
Yes, that's what we're saying.
Those
all of them.
Absolutely.
All of them.
All of them.
Okay.
But what we're saying is we would go through them to ensure currency and to see whether or not they're, they encompass everything. And they've excluded something, so we want to see what these things that they've excluded to determine whether or not we will exclude them as well, which requires the review for the next meeting.
But these are the minimum. Definitely all of these would make it, and people would not be able to apply, but there may be additional offenses that we want to consider based on the characteristics of the profession of teaching.
Go ahead, Ms. Wilkins.
Yeah, I agree with Member Green.
Okay. Go ahead, Ms. Wilkins.
Thank you, Chair. I need to indicate that I sit on the expungement board, and as such, I would wish for an opportunity to offer a tweaked list of offenses, because common law offenses are not captured in that list, and there are some things which I think have in regard to the nature of this bill that I would offer to provide a tweaked version of the list in the third schedule for your consideration, which you could send before your meeting so you could look at it. I don't want you to wholesale adopt what's in the third schedule.
And Chair, we agree with that, which is why we're saying we're reviewing it. But what board did you say you were on, Ms. Wilkins?
Expungement.
Oh, okay. Oh, excellent. Yes, Chair, I agree with that approach. I have no difficulty with that.
Okay. All right, carry on.
So we will revisit subcauses 3 to 5 with the inclusion of the excluded offenses.
Minister Williams?
Go ahead, SG.
Right. So I understand that there will be a revisit of 5. I just want to indicate that these chambers, we do not agree with 5. We think it should be removed. So the technical team, the ministry can consider. We don't usually put in this provision in our more recent laws about someone who is not pleased with a decision of the council can appeal to the Court of Appeal. We no longer have that kind of mechanism in our newer laws. The person would always have that right to judicial review, and that does not need to be put in law because that's a right that they have. So I'm just letting you know of our objection to 5.
So you're saying that once the submission has been denied by the council, that's it? Soljan?
It isn't it, meaning that person will always have the right to judicial review. They can go to the full court.
Okay.
But that doesn't have to go into the act.
Okay.
What this bill says is that they would have a right to appeal directly to the Court of Appeal. We don't agree or support that approach.
All right.
As a provision in this legislation?
It's in 5. 5 says where the council denies the reinstatement of a person under subsection 3 or 4, the person so denied.
Right. No, I get it. We don't need to explicitly make that provision in this legislation.
It shouldn't be a direct appeal, a direct approach to the Court of Appeal. What we are saying is that the person would have the right to get the full court to review the decision of the council because that is their right in law.
Okay.
So we think that should apply here.
All right, we agree,
right.
S3.
We're with you.
We take out 5.
But go back to Chair 3A-B. I want to see the prescribed document, the list of prescribed documents.
The thought process of requiring prescribed documents, though, we should consider it. Because that means that the forms, I don't know, do you need to say prescribed documents? Because what is going to happen is that it is not prescribed and then there's a problem. Is it fundamental? I'm not hearing it though. Well, I was going to make a comment, but anyhow.
We can take out the word prescribed, right? It would be any documents that the council requires.
Right. Yes,
yeah.
I prefer that.
Yeah.
So you don't have to have it gazetted and...
Yeah.
Right.
Yeah. All right.
Agreed.
Can I just offer, though, another perspective? So the reason you say prescribed is because at least there should be some public record of these documents. So if it's not prescribed, if it's not regulations, is there some other way that these documents would be published, for instance? So how would I know? Is it that the council is just going to, and I know the council is not supposed to act arbitrarily, I understand that concept, but how do we put in a safeguard in the bill? For instance, are these documents published on the website or somewhere? Because what this is, when you prescribe documents, it's a safeguard. And it's allowing the public to have access. It's ensuring that the entity will always act, not just reasonably, but that they won't just come up and create a document to suit a situation.
No. May I speak, Chair? I don't know that, I'm not a lawyer, so there are some terms I don't know what they mean in law. But we are looking at documents that would give evidence of retraining, re-education. We'd look at reports, counseling reports that the person has received proper counseling services and the outcomes of that. We would be looking for character evidence. So that's the kind of documents that we would ask for. If
noted. And I don't have a difficulty.
Is to be considered.
Oh. Sorry to interrupt you like that, Minister Gordon. I didn't mean to. Thought you were finished. And I'm saying our issue isn't the type of documents. The issue is when you speak about prescribed, you're talking about regulations. And as Member Braham referred to having the requirement to gazette them and so on. And whereas I understand that difficulty, is it then that these list of documents would be made available to the public otherwise? If they're not going to be done by way of regulations and gazetted, then would they be made available like on a website? We would prefer to see some sort of safeguard in the bill.
In other words, anyone applying must know the evidence that they need to bring forward in order to positively, hopefully, make their application. It can't be a situation where someone may say, well, they did not bring that, and so they would not qualify. It's important for them to know and to have some sort of a domain where they can have access to that information, and not a determination made only by the council. If you're applying for a visa, you know what documents you need to put forward.
Go ahead, SG.
Yes, so that's correct. And I was just going to add that there can always be a catch-all to leave some discretion in the hands of the council, but the main documents really, the public should know exactly what the basic list of documents would be.
So I take it we leave the word prescribed in then? All right.
No, that's not what I was saying.
No?
I was saying, no, because prescribed means regulations or rules which have to be gazetted. So I was saying, if you take it out, can you then put in another mechanism? So for instance, a suggestion is that the documents which are published, the list of documents will be published like on the website of the council or of the Ministry of Education.
Okay. So having furnished the council with the list of documents published on the website of the council.
No, well, I would ask the drafter to draft, because the point is you must provide documents.
I would just want to make sure I'm capturing
right.
what you're
so
saying.
I'm saying that person would provide documents, but the list of documents could be published on a website.
If Chairman if prescribe will solve it, I will not stand it in prescribe's way.
No, I take the point though, Member Graham, that prescribe does bring into, it brings in another layer of bureaucracy. So you would have to have the order, let's say it's an order drafted, then you would have to have it published in the Gazette. I'm saying that there could be another mechanism to achieve it.
We agree and accept what you're saying, SG, and the drafters will include that. So carry on, Mr. Gordon-Jones.
(62) If a person's conviction for a disqualifying offense is overturned or quashed on appeal, A, the person is no longer a disqualified person for the purposes of this Act. B, the registrar shall, on the instructions of the council, 1, restore to the relevant register or the roll of instructors, as the case may be, the name of the person. 2, reinstate the registration and reissue the license or the authorization to teach to the person on the same conditions on which the registration, the license, or the authorization to teach was held immediately before the revocation. And 3, cause a notice to be published in the Gazette and a daily newspaper circulated in Jamaica, specifying the matters in paragraphs 1 and 2. C, the person is entitled to the full amount of a salary which the person would have received if the registration, license, or authorization to teach of the person had not been revoked. And D, the council shall forthwith notify the employer of the teacher or the instructor, as the case may be, of the actions of the registrar pursuant to paragraph B.
Sorry, Chairman. This, apart from the item number C, item C, this is dealing with a situation where the conviction is quashed on appeal, So it is equivalent to them being acquitted. So the question I'm asking, yes, on appeal, do you need a separate section? The earlier sections deal with acquittal simpliciter. Do you then need a separate section that deals with acquittal on appeal? Is it so different of an acquittal why you need a separate section? I don't know if you follow what I'm asking.
Yeah, I get what you're asking. So,
and if that's, I ask that because, of course, you run the risk of differences. Remember, we had a long debate about what the others meant. So that's the first question. And maybe I could have, maybe Mrs. Douglas Sherland could answer that. I don't know if you. It appears to me that once you're acquitted, however acquitted, then you really shouldn't need anything special. She like talk, but you're not hearing what you say.
So the first one, member, was in relation to suspension, particularly in relation to suspension.
you have clause 5, 60, subsection 5. I guess that deals with the acquittal for disqualifying offense.
That is when the person was suspended. 5 is in relation to suspension.
Disqualifying offense, acquitted of a disqualifying offense. Isn't that what's
for
there?
which the person's registration was suspended.
But this one, 62, is dealing with a conviction for a disqualifying offense, and it is overturned or quashed on appeal.
Right, so the fact that the person was convicted, then based on the scheme of the bill, then the person's registration would have been revoked.
So do you have a situation for the revocation of the person when they have been convicted simpliciter?
Yes, there is a provision that speaks to the revocation.
Well, even so, but I just wondered if you need a section that speaks about an appellate acquittal. Yes? Okay. Well, the second question has to do with the payment of all of these monies. Entitled to full amount of salary which a person would have received if the registration and so forth. And who is to pay that? The council or the employer? Well, you see, this is a very interesting situation, you know, because the employer and the employer need not necessarily be the government. This is a process that could take eternity. And then after it is ended, the employer of the basic school is to find 10 years salary to pay. It is a little challenging to me. I'm not saying they shouldn't be paid, but if it is within the power of the employer, then the employer will quickly deal with his thing so that he can cauterize his losses. But this is outside of the control of the employer. And we have now imposed a liability indefinitely on the employer, Minister. I think it needs a little revision. I mean, the government obviously can always afford it.
Really?
But what happens if the employer is a private enterprise running a school? It may be a church running a school, it may be a trust. And they are to find 10 years salary, it could close the school.
Member Braham, when the Professional Practice and Conduct Committee and the council have some time frames. have some time frames in which it conducts its affairs. Those are stipulated in the legislation. But in this case, there's no control whatsoever. This is left up to the determination and the ambit of the court, the judicial system, which can be very expansive in nature. And so I quite agree with you. Yes, there are those remote opportunities to agree. Because in this case, I can understand a private institution who is exposed under the purview of this legislation that might be forced now, based on what we are imposing, to pay, and might be forced to close based on this amount. So you're quite right. That exposure ought to be reconsidered in this case. I can appreciate, as a trade unionist, the exposure to the individual who may have been out there, but in this case is acquitted. But look at it. This is an acquittal up to an appeal stage. That might be even longer. So we really have to consider the best way to treat with this.
So Chair, my question now is, how would we do justice to that person who has been aggrieved in the circumstances?
Well, the present situation, Minister Chairman, if you're working with a company and you're charged with an offense and you're not available to work, at some point the law would have treated your contract as being frustrated and it would have come to an end. Or if it's not frustrated because you're not available to work, the employer would bring your contract to an end. So we are changing the law in that regard and say your contract remains open indefinitely and we must pay you, which is a good thing if I am the teacher. I mean, I would love that. But there's a problem.
Go ahead, Dr. Gordon or Ms. Gordon-Jones.
Chair, I guess we would have to reconsider this provision. And or is it that member Braham? Is it that we are to remove the provision?
That would be my recommendation. But except for government.
No. Because to remove the provision, it would be removing the opportunity for the reinstatement and the registration. Not that part.
C.
Just C. Okay.
Which also be paid by the employer.
Assumes, it also assumes that the institution would have had to fill that vacancy during the period. And they would have to be paying a teacher. So you can't be saving up the money.
The teacher has to be paid. The private sector schools, they, in their contract with the teacher, they must put a clause in the contract that indicates that the teacher gets into professional misconduct and for whatever reason the council has to take the teacher's license or whatever, then they must have terms for that. But once there's a requirement that the teacher has to be paid, the teacher has to be paid by his or her employer. So it is up to the employer to determine the terms of the contract. with the teacher.
Once you have it, Chairman, as it is written, this provision would override the contract. So you have it in your contract.
About the government is the major employer.
Yes, but there are others who are not government. Right, and I'm thinking about the church and trust schools. Those are private, even though charitable, private charities. It's not fair.
Just to highlight that there are other remedies at law for persons who could be in a situation where they are acquitted upon appeal for a particular offense. There are remedies that a prudent attorney could recommend to their client to be able to be compensated. Just saying. And it's nothing that we should put in this law.
All right. So members, what I hear us saying is that we do not have to detail this provision in this law, that it should be omitted because there are other remedies available in law for the person. Ms. Gordon-Jones? All right, you're agreed. So members...
I'm sorry, Chair. What are these other remedies that are available to the person? What remedy could the person have? It just means the person is going to be out of pocket.
Member Hamilton?
Doesn't mean what, SG?
I said the person will be out of pocket. What remedy does the person have?
No, so I'm thinking more along the lines of certain claims that can be brought under specific circumstances. I mean, I don't really want to get into it, but at law, where somebody would have gone through a particular may have been charged with an offense, gone through the process, is acquitted, there are remedies at law that person can explore from a civil side if it is that they so desire. Thank you.
I'm not sure that the person really would have any kind of... This is the reason you have this provision, you know. So this is something that applies in the public service. And I understand the consternation of certain members about how it would
Member
impact.
Graham.
No, I don't think you're alone there, Member Graham. And I have a colleague here that I'm also violently disagreeing with, because at the end of the day, as much as it is not the fault of the institution, it is also not the fault of the individual. And what removing the provision will do is leave that cost to be borne by the individual. And as much as the institution is that could be a charity, maybe a church school, and it does not have deep pockets. Neither does the individual. And again, at no fault of the individual. And without this provision, I'm not sure that the individual really has much remedy at the end of the day to recover, because this is not. I can't see how they could bring a claim to say that the employer must.
Of course not.
No. Exactly. So I'm just pointing out the consequence to the committee of removing the provision. That's all.
I would just like to say this. Generally speaking, Chairman, when you are convicted, you are charged with an offense, and it takes whatever time to be resolved, and it is resolved in your favor. The present system doesn't provide any compensation. And indeed, you may be convicted of an offense and later on appeal acquitted. There's no compensation that you get. Now, if you are in the government service and the government chooses to, if somebody is charged with an offense and it is going through and they have to be suspended because of the charge, and the government chooses to pay these persons, that's fine. But this is a regulation for all teachers, regardless of where they're employed. So the teacher is charged with an offense, maybe sometimes unrelated to the school. He has to be suspended until the matter is resolved. The system takes its own sweet time. And at the end of the day, the school who did not cause this matter is to come and pay for it. It cannot be fair. It cannot be. If it is a problem that needs remedy, then you have to consider whether the public purse would want to remedy it. But how can you impose it on the school? I just don't know.
And that person may not be able to recover anyway, SG, because the school may not be able to afford it anyway. So we have to look at those factors as well.
Right. All I'm saying though is there's unfairness on both sides. It's not on one side, it's on both sides. But in any case, if you remove the provision, government also would not pay, because normally government pays when there is a legislative requirement. So I'm just pointing that out.
So is there a middle ground? Is there a revision to this?
It appears then, Minister, that there may well be a policy consideration. I mean, if it is that the government is of the view that these teachers should be compensated, then the government should compensate them across the board. But yes, but a teacher that in a private entity that has not worked and his position has been filled for the last 5 years, the entity now, having not caused the teacher to be out of work, to turn around and find that 5 million or 10 million or whatever the figure is for the 5 years, to find that and to pay is inequitable.
You know, it's difficult to find even a middle ground for this. Because of the mere fact that, yes, that teacher would have been out of pocket and exposed. But considering that this was may have been a disqualifying offense that was conducted out of the school, not an act of transgression that took place whilst performing the duties of a teacher. And now, because of the expansive nature of time under the judicial review system, the school is going to be bounded to accept liability around the expense of this payment. I understand and I personally accept the fact that yes, that teacher who is an employee is going to be out of pocket. But this is an exceptional circumstances where we are affixing the legislation to consequences aligned to a disqualifying offense in the treatment of the outcome and the result of reinstatement, which places a greater burden on an employer. And whilst the provision is there, yes, the provision allows for both the employer being government as opposed to the employer being private. And so that's why it's very difficult to come to a middle ground because of the risk of exposure.
I'm not so sure, members, what's the middle ground, if any. I say I'm not so sure if there's a middle ground on this one. Yeah. All right. I see Member Cuthbert packing up. Okay. I know we've been here now. All right, members. We are going to bring this session to a close. There are many items for reconsideration. When we come back at the next meeting, we'll begin at, well, the date that we have currently is Thursday, June 22nd at 2 p.m. And when we get back, we have section 62C to complete, all the way to 85, 2 p.m., all the way to section 85, and the first and second schedules. All right, members. So the next date that we have is Thursday, June 22nd at 2 p.m. And for consideration, further consideration, clause 62C and all the other amendments all the way through to 85, plus the two schedules, first and second schedules, in terms of the amendments there. Any remaining comments, remarks from anyone, any member, or the legal team?
Chair, just to remind you that there is also a document that was circulated before in relation to some unresolved issues based on previous sittings.
Some unresolved issues?
Yes, Chair. So that is a paper, that is a document that was submitted.
Is that the one in relation to whether or not the, teachers should apply for police records? That one?
That is
that
one.
That was already settled.
No, Minister. That is one issue. That is one issue.
That all persons who applied, No, it was already settled. It was agreed by.
No, it wasn't.
It was
No, Chair,
agreed that persons should apply for a police record. What needs to be done is just a streamlining so that persons don't have to wait an inordinate amount of time, but it was settled.
The legal team is not of that understanding, Chair.
It was. We had a robust debate around it. And there's no way we could have gone through all of this and we say no to a police record.
Maybe, Chair, for clarity, at the next meeting, we could just indicate what the decision is for the records.
All right, members, so we come back to the next meeting with much still to be considered. I thought we were almost at the end. All right, thank you so much, members. Thank you for your time and your commitment to this process.
Thank you, Chair. You're welcome.